Well, we've got what pretends to be a new filing by the Department of Justice under Donald Trump in the birthright citizenship case in front of Judge Boardman. But when you look at it closely, there's no appropriate argument there. There's no. Sometimes when I read what is being filed by this Department of Justice, I have to like rub my eyes in disbelief. I'm like, do these people even understand the legal principles that they're arguing? After the Supreme Court's decision about nationwide injunctions and birthright citizenship, you have to have expertise in class action cases in Rule 23. I'm sorry, Mr. Yuri Fuchs, who signed this piece of paper on behalf of the Trump administration. You seem to have neither. And their argument instead to Judge Boardman is that she should deny class certification of all people similarly situated who are being denied birthright citizenship or their babies are because they aren't a proper class, that the injunction that the judge already entered is up on appeal, and therefore she can't enter a new one, and there's no appropriate case law for that principle. And what they have done in running to Judge Boardman in the CASA Incorporated case within hours of the Supreme Court's decision in the CASA case was to do exactly what the Supreme Court told them to do. The 6-3 MAGA majority, including the concurrence of Justice Kavanaugh, they said, well, we're going to probably take away nationwide injunctions unless a group of states brings the motion. But you can use Rule 23 class actions under the rules of civil procedure and get a preliminary injunction if you fit all the criteria. That's what Justice Kavanaugh said to do. That's what the majority decision of the 6-3 majority said to do. Even Justice Alito, who said, well, trial judges better look carefully at Rule 23 and make sure there's no gamesmanship going on, suggested that you use Rule 23. And now the plaintiffs, led by Georgetown University and their law center, have done exactly what the Supreme Court told them to do. They threaded the needle perfectly. But to the Department of Justice, who wants to bury their head in the sand, they're like, oh, it's another nationwide injunction. It's a class-wide nationwide injunction. It's not. It's the certification of a class with a request for a preliminary injunction or temporary restraining order, which is exactly what the Supreme Court said to do. Come on, Mr. Fuchs. You can do better than that. This is going to get quickly rejected by Judge Boardman. I'll cover it right here on Legal AF. 9 different cases, 9 different judges, including some Trump-appointed judges, all came to the same conclusion. Donald Trump's attempt through an executive order 14,160, where he tried to declare that people who are babies that are born from aliens or temporary residents in the United States are not entitled to birthright citizenship. Where does it say that in the 14th Amendment? Nowhere. Where does it say that in 100 years of precedent going by the Supreme Court? Nowhere. So he just wants to undermine the 14th Amendment, doesn't want to amend it, just wants to clarify it, clarify baby's citizenship out of existence. So let me get this straight. Under the Trump administration, a baby is born in a U.S. hospital, but it is citizenless, he or she. It is citizenless. It can't get a passport. My baby got a passport in the first 90 days. It has no nation. It's supposed to live at the airport, apparently, like Tom Hanks in that movie. It can't get federal funding. It's not recognized as a U.S. citizen. It can't get food aid. It can't get healthcare aid. Who's supposed to take care of this baby? And who's supposed to give it citizenship? What, the country of the parent who's maybe here under a mixed bag immigration status? The child wasn't born in fill in the blank, Mexico, Venezuela, Ethiopia, Honduras, wherever. Have they thought this through? It must be like their papers. So right on target, I said at an earlier hot take, as soon as this happened, that the Trump administration was going to try to argue, as they have before, that class action Rule 23 is inappropriate for birthright citizenship attacks. What is a judge supposed to do? 9 different judges, including Judge Boardman, have all looked at the very issue, including those Trump-appointed judges, and said the same thing, that the executive order is unconstitutional. Then they blocked it. Then it went to the United States Supreme Court. And 2 weeks ago or so, the Supreme Court said, well, we're not going to deal with birthright citizenship per se on the merits, but we don't like nationwide injunctions. So try it another way. Send it back to the courts. Let the lower courts figure it out. All right. And you could try Rule 23. That seems to be a better fit. Great. Casa Inc., within, I'm not kidding, 3 hours, because they were ready, filed their motion for class certification, emergency motion for temporary restraining order. Judge Boardman pulls everybody together and says to the Trump administration, because nobody trusts the Department of Justice under Donald Trump. Nobody trusts the officer in the court is going to use their professional responsibility and ethics to tell the court the truth. We've got whistleblowers who blew the whistle on the Justice Department and said they're lying to federal judges. So Judge Boardman said, are you going to deport babies? Literally said this in a hearing 2 weeks ago, 10 days ago. Are you going to deport babies while I'm making my ruling about class certification and class action status and injunctions? And they filed and they said, no, well, we're not sure. Well, probably not. She said, put it in writing. File a document in the court the next day. A week ago, they filed their document and it didn't say they weren't going to deport babies. If I were Judge Boardman, I would have already entered an injunction, a protective injunction, and done a temporary certification of the class, but she didn't do that. So now we get the piece of paper from the Trump administration, and right on cue, written by, I guess, Yuri Fuchs, some lawyer who joined the Department of Justice in January. I mean, he was with the U.S. Attorney's Office for several years before that, but he doesn't know. You can tell he doesn't know class action jurisprudence or law. He's not citing it properly. His biggest argument is there's just too many different plaintiffs that you can't. I don't know why I'm doing this whining voice for him. I don't know what he sounds like. This is my artist rendering. You have too many plaintiffs who represent all different types of immigration status, so you don't have what's called typicality under class action analysis. You need commonality, which is a rubric we use as one of the elements for class action, which says that the claims of the class or the subclass, hold on to that point, have to have common interest, commonality. Okay. Typicality is that the plaintiffs, the putative plaintiffs' representatives for the class action have to have claims that are typical of the class. But he totally ignores that you can have subclasses. So he goes through his whole elaborate analysis in his brief, if you want to call it that. He says, well, 3 of the proposed plaintiffs are here on an asylum application. I'm like, okay. 1 is here on a tourist visa, right? 2 under a student visa and 1 under an H-1B visa. And so they're not typical. Have you ever heard of subclasses? The reason that they join this whole group together is to cover the waterfront of different types of immigration status. They'll all represent the class. You'll subclass it into asylum seekers, tourist visa, temporary protective status, student visas, H-1B visas, and others. And that's how you handle this kind of issue. But it doesn't surprise me that they're attacking class action. The other argument, the last argument they make, is equally nonsensical, should be quickly dispatched by Judge Boardman, which is the argument that she already has an injunction that has to be revised pursuant to the Supreme Court decision, and it's up on appeal as well. Okay. Judges are allowed to issue subsequent remedial orders and subsequent injunctions. I assume she'll vacate her other injunction and she will replace it. So it'll be a search and replace. She'll replace it with the class action certification and the new injunction. What's the problem? I mean, listen, I never underestimate the abilities of my opponent. And John Sauer, who is the Solicitor General of the United States, has done, if you're just looking at it from a clearly, has he been successful for Donald Trump on appeal through the Supreme Court? He has. But I don't think he's reading or writing any of the papers that are being filed by the Department of Justice, which is sort of weird because when I've done litigation, I always bring in an appellate expert to review my papers if I know there's going to be an appeal. Doesn't look like to me John Sauer's writing any of these papers. I don't know if it's just plausible deniability or what. But these are really poorly written and poorly argued. And that's a good thing. So here's what's going to happen. Judge Boardman's going to get the next piece of paper in from the plaintiffs group. I think she's going to certify the class. She's going to create subclasses to solve the problem that Mr. Fuchs can't seem to figure out about what are we supposed to do with all these different groups? And that solves the typicality problem and the commonality problem. And then she's going to issue a preliminary injunction. And if the Trump administration doesn't like it, which they won't, they can take an appeal. and then try to take it up to the United States Supreme Court on an emergency application this summer, because it looks like the Supreme Court's working again. I thought they were done at the end of June, but they're issuing orders still on emergency applications. That's still coming out. And they'll have to just work overtime this summer on these emergency applications. Or they'll roll it over for a full briefing come the first term, the new term, the first Monday in October. You're here. You're on Legal AF. It's Michael Popok. I'm traveling, but I'm still reporting for you. Take a minute. We don't have a paywall. The only way we need you to support us, the only way is free. Hit the subscribe button. Help us continue to grow this pro-democracy channel. I curate the channel. We got 12 amazing contributors. We got shows like Unprecedented. It's complicated. We've got Pragmatic Optimist. We got Court of History, Court Accountability Action, Shan Wu, Dina Dahl, you name it. Sorry, I'm dry on this trip, but we need your help. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.